Welcome to Tales from the Training Room, Burkett's bite-sized podcast series from the Shaping Excellence team. In this episode, Johnny Shevlane and Laura Herbert provide some insight into current conversations surrounding beliefs in the workplace. They look at what constitutes a belief and what beliefs are protected under law. Johnny is our dedicated employment law trainer, and Laura Herbert is a solicitor in our employment team with experience in multiple sectors. They begin their discussion by examining how this has become such a hot topic of conversation in workplaces, and what legal developments have fueled this public interest.
So, today, what's the reason why we're looking at this idea of belief discrimination today, Laura?
So the Employment Tribunal has handed down cases over the summer which relate to the conflict between people that have gender critical beliefs and people that are on the other side of that view. So people tend to be in the transgender community and their allies. And the court, over the course of the summer and over the past few years, has really interrogated where that comes into practice in the workplace, and in particular what employers are required to do and what they can't do in terms of how they discipline or manage their employees with that conflict.
What we really need to get to is what is a belief and what does belief mean under the Equality Act, because that's the focus of today.
Yeah. The Equality Act is trying to give some kind of protection to people whose beliefs don't amount to a religion, but they are nonetheless a philosophical belief capable of being protected and protectable under the Act. And so we looked at one of the key cases that looks at this is the Granger case. And I think Johnny's going to take us through an application of the Granger test.
There were 5 criteria the court basically set out, which were the things which you need to prove if you want to say to the court, I need to be protected because of my belief. The first one is that I must hold that belief genuinely. I must actually hold this belief genuinely. And the case that was mentioned by Laura is McClung, which was a Scottish tribunal case. And in McClung, the individual was a supporter of Rangers Football Club, and he ironically believed that he'd been discriminated on the basis of the fact that he believed in Rangers Football Club, or he was a supporter of Rangers Football Club, and he thought that was a belief worthy of protection.
Yeah, and I think in terms of background to that, his employers were Celtic fans. That's the argument that he made, and his contract with them wasn't renewed, or he was told that he wasn't able to work with them anymore. And he thought there had been some unfortunate comments, I think, from his manager about the difference between the football fandom, and he tried to bring that claim to the Employment Tribunal. Johnny and I really like doing this as a training exercise to go through the 5 Granger criteria on the basis of McClung and seeing whether belief in football and being a fan of a particular club can amount to a belief that's potentially capable of being protected under the Act.
So in McClung, he had to show that he had a belief which was genuinely held, and he said that I fully am a supporter of Rangers Football Club, and I can showcase that by the fact that I have a season ticket, I go every week, I feel excited about the fact that games are coming up, I spend a huge amount of my income on supporting Rangers. And like most claimants in this area, he was able to pass that first hurdle. It was genuinely a genuinely held belief. The next question is, was it a belief that was not an opinion or a viewpoint based on present information? That's quite a difficult one. It's quite a difficult one in a lot of cases. In the McClung case, the Employment Tribunal decided that they didn't want to consider basically support of a football club as something which was not just an opinion or a viewpoint. They were very much minded that it was a lifestyle choice and it wasn't something which was akin to a religion in that sense. So they decided that it didn't get over that hurdle of being a belief in that particular case.
Controversial.
Quite controversial, potentially quite controversial. The next one, which I think is even more controversial, was that the belief must be something as to a weighty or substantial aspect of human life. Now, I'm a big football fan. I support Tottenham Hotspur, and I would say that that's a big part of my life, supporting that football club. And I think that you could make a good argument to say that football is a weighty and substantial aspect of human life, and certainly football fans would try to argue that. The tribunal judge in this case said, no, we don't think that football is an important and substantial aspect of human life.
I think on the basis that she was saying, what you're there to do is to support someone getting a goal in the back of the net. It's not weighty and substantial in the way that the Granger criteria requires.
Mm-hmm. Again, I think potentially controversial, but that's how the tribunal interpreted that one.
I'm an Ipswich fan, football club, by the way.
So the next thing is that it must attain a level of cogency, seriousness, or importance. And again, because of the fact that it looked like a trivial idea, supporting a football club according to the tribunal was something which is quite trivial. They didn't think it had that cogency and importance that was required by the criteria. They said there's lots of different ways you can be a football fan. There's no subscribed way you have to do it, basically.
Yeah.
So in that case, they decided that again, it didn't pass that fourth Granger criteria. And the last one, which is kind of most important in the area which we're talking about today, is it must be worthy of respect in a democratic society and not incompatible with the rights of others. And in this case, basically on the basis of it being so trivial, they decided that in this particular case, they would say it wasn't worthy of respect because it's so trivial, which is the kind of the opposite to what we're going to be discussing in the Forstater case. So in Forstater, the question was whether or not it was something which we wanted to be protecting. Whereas in the McClung case, it was more a question of it's so unimportant that we shouldn't be protecting it in that case and in that way. So moving on to Forstater, I'm going to pass over to Laura to just discuss Forstater.
Yeah. And so just to delve into a little bit more into what the courts have decided are protectable and not protectable, we've got two kind of sides of the coin based on the Granger criteria. So we often talk about things like ethical veganism being protectable under the Act, because the claimant in that case said that he lived his life through the values of veganism. He ate in the right way as a vegan. He campaigned for it, and he was able to show to the court that that was something that was weighty and substantial and sufficient to be protectable. We've also got we'll come to this, but gender critical beliefs are protectable. Things that are not protectable would be things like football.
Well, football, yeah, it appears to be so. Political beliefs or specific following of political parties has been found not to be a protectable belief.
Yeah.
Although there might be things at the edges where you might have a protection for a particular type of political belief.
Yeah. General morals of society was found to be too broad to be capable of protection. They've said in the later cases that something like Nazism and totalitarianism wouldn't be capable of being worthy of respect in a democratic society.
But it's a high threshold, a high bar now.
And then it was quite interesting to explore things that haven't been tested by the courts that might be protectable. So we think that would include, let's say someone's a Republican, that is likely to meet all five of the Granger criteria.
So believing that the monarchy should no longer exist, for example, that could well be something which is protectable as a belief, even though a lot of people would be offended by that belief in the same way as what we're talking about with gender critical. Yeah,
and same with unionism. There's lots of things that are heavy divides and heavy conflicts, but nonetheless, if you're falling on one side and the other, the Employment Tribunal will decide that if you are discriminated against or treated less favourably because of those beliefs, you may have been discriminated against at law.
Okay, so moving on to the case of Maya Forstater.
Maya Forstater was a consultant. She worked for CGD Europe. She was a visiting fellow, essentially. And she, as I think Johnny said, started tweeting prolifically within the trans space and the anti-trans activist space almost. I mean, it's been decided later that it wasn't, it was potentially offensive and potentially distressing, but it wasn't hate speech. But we're in a very grey area here, aren't we? She, her contract was not renewed with CGD Europe following these tweets because her colleagues started complaining about them essentially and said, this makes us feel uncomfortable, this makes us feel distressed, we're not happy with having her in our working environment. And in response, CGT didn't renew her fellowship. She took them to court on the basis that she had been discriminated against for a protected belief. And at first instance, so employment tribunal, the judge there confirmed that she didn't meet all 5 range criteria. Her belief in gender critical beliefs was not capable of being protectable under the Act because it was incompatible with human dignity.
Of others, being trans people reading her tweets. People.
Precisely that. And that what she was saying was capable of being harassment, and on that basis, we as a society should not be accepting that. So she appealed this decision, and it went all the way to the Employment Appeal Tribunal, and we've got a really interesting judgment that was handed down. It was in June 2021, and they disagreed with the Employment Tribunal. It's got to be said here, they were at pains to be clear that they don't take a view on the merits of either side. And they were very clear throughout that if someone is making these potentially trans exclusionary comments or gender critical beliefs comments, that it may well be capable of being harassment. They were clear about that. But their ultimate judgment here is that it may well be profoundly offensive and even distressing to many others, but these are beliefs and must be tolerated in a pluralist society. And that's where the nub of it comes down to.
Let's take a step back from Forstater and just look at what's the situation for employers now. So you've got an employee who holds gender critical beliefs, or perhaps you have an employee on the other side of the debate who is showcasing their beliefs on social media prolifically and is upsetting other members of your staff by what's put in their tweets, by what's being said in those tweets. What's the first port of call for that employer when they first become aware of those social media posts?
I think the key here is to get all the information that you can about it. The first thing you need to look at when someone's tweeting anything potentially, or tweeting anything online, so in the social media space or outside the workplace, is to consider whether it may be an emanation of a protected belief. That's your first one. In gender critical beliefs, it probably is a protectable belief. So your next step is to gather all the information you can around this, interview people, make sure that you've got all the information on the ground, and then make a determination as to whether or not you think that the actions or the comments complained of would amount to harassment. And you are entitled to make a judgment call on that as an employer. That is within your right. And you obviously have a duty to safeguard the safety of your employees and make sure that the environment for them is a comfortable one and a safe one. But what we're seeing now is that a knee-jerk reaction may well be punished in the employment tribunals. There are lots of factors, though, that we look at, isn't it, when we're advising clients in this space. And one of them is it really comes down to, as we were talking about, the manifestation of that belief. If it's not directed at someone, if they've got a line in their Twitter bio or whatever it is, their profile, saying my views are my own, and there's no connection between that employee's what they're saying on Twitter and their role at work, or there's no connection between their presence online and your workplace, then it would be much more difficult for an employer to step in that scenario, because it would be difficult to argue how that conduct affects the reputation of your, or whatever it might be, their role in your workplace.
Yeah, so you have to think about, why are we going to discipline this person? Are we actually worried about other employees within our workplace who are being exposed to harassing conduct online or harassing treatment online because of these tweets? Or are we worried about our reputation? And if you go down the reputation line, you have to really draw a link between that kind of speech and its negative impact on what you do as an organisation. It can't be, somebody's made a gender critical tweet, that's going to reflect badly on us because 10,000 people on social media have said that they don't like this particular tweet.
And it's blown up, let's say.
Yeah, exactly. That's not going to be enough necessarily for the employer to say we've had reputational damage, because the tribunal is going to say, why have you, an accountancy firm, felt that has actually had an impact on your ability to attract customers to actually use your services as an organisation? It might be tricky for them to argue that.
Yeah, that's not to say it's not possible. It's just that the rationale for it needs to be really carefully thought out and documented, I think, at the time.
I think that's a really useful way to end. Thank you so much, Laura. So the big takeaways for today: a lot more beliefs might be protected than we think.
Yes.
And we need to be aware of that when we are thinking about disciplining somebody for having made a tweet or having made a comment within the workplace, which potentially is a manifestation of that belief. And we need to really look at these cases in the way in which we treat any other conduct situation or conduct position, and think about things really carefully before we come to a decision which could otherwise be described as knee-jerk.
Yeah, I think that's right. And I do think that employers' policies in particular can really help with that, to get that nuance right and to make sure that they are standing in the right place at the moment. Yeah. And the other thing that we often say to our clients from our training war chest is that practical workarounds are often the very best way to deal with this kind of thing, as it always is in employment law.
Yeah, negotiated solutions are available. Yeah, absolutely. Yeah. Thank you very much, Laura. Thanks
no
for that.
problem. Thank you.
That was Johnny Shevlane and Laura Herbert discussing beliefs in the workplace. If you found this episode of Tales from the Training Room useful, our Shaping Excellence team has a whole host of employment training courses available. Our training is practical, insightful, and always provided by the best legal professionals. Head to our Shaping Excellence training page at burkitts.co.uk to find out more. This podcast has been produced by Burkitts. The content of this podcast is for general information only. It is not and should not be taken as legal advice. If you require any further information in relation to this podcast, please contact us in the first instance via our website, burkitts.co.uk.